Hello, everybody. Oh, you're brave. You're a brave puppy jumping up here with Billy right there. Hi, Earl. I'm coming. And yes, there's treats. There's even treats for me. I don't know what it is, but I think it's from Eileen Carlin. It came yesterday, and it came after the first stream, so I just set it aside so that I could open it now, and I'm looking for something sharp. Not having much luck. I keep the sharp things hidden. All right, so the box says you're part of something uncommon. It's from Uncommon Goods. Wasn't that 3? That was 3. Quit playing with me. Support independent makers in creating innovative designs. Say no to leather, feather, and fur, and always have. And donate to nonprofit partners, over 3 million so far. That's the company. Have some paper. There you go, Earl. All right. Have a box. They like the boxes. Hey, you got your treats. You quit. If you want another treat, there's 3 in this bag. That's exactly enough for tomorrow. No. You're done. Go eat some regular food. Hey, stop. This is for me. I get this. I got a nifty little bag. I love the bags stuff come in, especially when they're reusable bags. It makes me so happy. Oh! You know what's so awesome is when I was getting my socks out tonight, I was actually sad because I have no winter socks. But now I have a pair that says owner of the world's cutest dog. Oh my gosh, I love them. Oh, is this beautiful? Oh my goodness. This is so gorgeous. I love it. Oh my gosh. Juliet Meeks is a watercolor artist based in her hometown of Narlands. Her artistic and entrepreneurial career began in high school when she started sewing and selling her handmade clothes at local art markets. Juliet's journey has taken various turns since then, from making handmade jewelry with vintage postage stamps to the watercolor illustrations and patterns she produces today. She enjoys painting florals because of their organic shapes and opportunity, as an avenue for color exploration. Most days you'll find Juliet in her studio with her dog Roxy, dreaming up new pattern ideas, teaching classes for other artists, and sharing her process along the way. This is so beautiful. It's got a to from card, but there's no name on it. But I'm pretty darn sure, that this is from Eileen. Oh my gosh, Eileen and Carlin, thank you so much. Oh, there's this little card in here. Maybe this has to from. Yep, April Searing. Happy birthday, love, Eileen. You are so amazing. You guys are all so good to me. Oh, it has a handle. I love it. Thank you so much. Oh my gosh. I love the colors. This is just beautiful. I'll have to find a shirt that I can wear with it, and I'll have to learn how to do all those fancy scarf ties that they do. I don't know any. Let's see here. Yeah, that's definitely not it. I will figure this out. I will learn this. Now I mussed up my hair. Oops. Do you know how long it took me after my shower to get it just right? Like I was trying out this like the Texas bangs thing, but I don't have any hairspray. So I was just doing that and like trying to get them as high as I could. My hair is still a little wet from my shower, but you guys are used to that. There we go. That was a good pass. Oh my goodness, you guys. So, hello, Manuel. Hello, Builder's Wife. Well, I am Central Standard Time, so it is 11:55 for me. Hello, Saul Goodman. Oopsies. I'm opening my stuff here. Hello, Jerry Matthew Boyd. Pretty close, pretty much, sort of, yeah. I try to do it every night, but every once in a while I will pass out while editing, and on those nights I just stay asleep. Excuse me. Hello, Nana Laura. Hello, Charlie. Get him, Nana. Hello, Eileen E. Carlin. Thank you so very much. Hello, Mortimer Duke. Ha. Earl's yelling at you. Hello, Mari. Hello, Ginny. You just wait. We'll get her Halloween costume out. Oh, and by the way, hello, Catherine Gaston. Yeah, but they don't listen when I tell them to open things for me. Like, I give them direction and they just don't listen to me. And I don't know what good they are. That's okay. Earl found the paper. There was this one time, like, you know, those people that come around asking you to buy magazines and stuff. You know, I'm in college and I'm selling magazine subscriptions. No, you're not, but okay. Anyways, I had one of those visit me, and they were asking me if I knew which houses had children, because those are always the easier ones to sell to. And I'm like, I don't know. I think, okay, that one I think has a kid, because I know they've got 3 dogs over there, but I think I've seen a kid running around. And there's a dog, there's 2 dogs in that house, and there's a dog over there. They've got a white poodle. They don't have any kids. I think they got grandkids. So like, I didn't know any of my neighbors' names. I just knew which houses had dogs. And then from there, I was like, I think I've seen a kid playing with the dog. Hello, Patrick B. Oh, thank you. It's so beautiful. My daughter, she's going to love it, because those are actually like her favorite colors. And she has a shirt with a very similar print. And my daughter does watercolors, like, and my daughter's an artist. So when she sees this, she's going to flip out. And I'm going to be like, nope, it's mine. Oh, it's gorgeous. Thank you so much. Hi, what's up, Panette, honey? Hello, Linda Applegate. That's amazing. I am so happy for you guys. Oh, what a blessing. That is beautiful news. I just had you out. You cannot have to go out already. Are you alerting me to Earl? I know. Go play with Earl. Go play with Earl. Or lay down. Whatever. Do what you want. Earl, what's up? Okay, something's up. Okay, guys, I'm gonna have to go figure out what's up. So, anyways, we've got a great show tonight. It starts off with what happens when you put up your house for collateral on somebody's bond. Yeah, you could lose your bond to bail in jail, like these people. And then we have all of the hearings, and then the explosive ending, where Jill actually lies straight to the judge. 2 episodes of that. And I forgot to do this.
Next matter is our file number 2503083 LT. This is a case of Troy Eisenhoff versus Pamela Charles. Is Pamela Charles present this afternoon? Is Troy
Yes, I am.
Eisenhoff? Are you Pamela Charles?
Yes, I am, Your Honor.
Okay. And is Troy Eisenhoff present this afternoon?
Yes, Your Honor.
Mr. Eisenhoff, have you worked on any resolution of this case prior to coming to court today with Ms. Charles?
No, sir.
Ms. Charles, I'm showing you before the magistrate in this case on the 10th of this month. At that time, we're advised of your right to counsel and financial assistance. At that time, as required, we adjourn this for a period of 1 week until today's date. As of today, no attorney from Legal Aid of West Michigan has filed any appearance on your behalf, so you'll be representing yourself in court this afternoon. Mr. Eisenhoff has filed what's called a termination of tenancy complaint. What he indicates is as following, that he has purchased the property at 118th Avenue and he would like you to leave. It looks like he purchased this through a foreclosure. So Ms. Charles, first of all, do you have any lease or anything else in writing that you believe allows you to stay at this property on 118th Avenue?
It's my property. I bought it, you know, so I don't know what he's talking about.
Okay. All right. Well, ma'am, here's what happened. It looks like Big Brother bail bonds took out some type of a second mortgage on that property. The property then went to a foreclosure sale, and there is a sheriff's deed that was received here by the court indicating that Troy Eisenhoff was the successful bidder on the property, and a sheriff's deed was filed with the court as part of this case. It looks like the original was filed with the Register of Deeds on December 19th of 2024. So as of December 19th of 2024, Troy Eisenhoff owns the property after the mortgage was foreclosed on by the bail bond company. At this time, he would like you to leave. And again, do you have any written documents to show that you are currently the owner of the property?
Yeah, I bought it for my friend. Yeah, I do. It's my
Okay,
property.
well,
And the bail bond never contacted me that the lady that was making the payment never defaulted the payment or anything. I didn't get no notification from him. He came and delivered a paper and said I had until June 1st to call and clear up the payment, okay? We called for 2 months and a half, and he never returned a call or anything. And when he did, it was too late, he said. No, I tried, you know, to pay the payment to him, and no, I'm not going nowhere because he didn't do me right, man. That's wrong.
Can I speak, Your Honor? Can I say something?
No, ma'am. Ms. Charles, again, I do have in the court file a deed that indicates Mr. Eisenhoff is the owner of this property. Can you provide me with any deed that indicates you are the owner of this property? And that deed would be something that was filed with the Allegheny County Registry of Deeds office.
Yeah, I do.
What's that?
Do.
I can't understand you, ma'am. Do you have a deed that says
Yes,
you're
I
the
do.
owner
I
of the
do got
property?
my deed.
Why didn't you
Yes, I
send
do
that
got
to the
my-
court?
Well, I didn't think I need my deed to show in court.
Well,
you know,
he's trying to evict you from the property. He's saying he is the owner. Who did you purchase the property from, Ms. Charles?
Mr. Olson.
Mr. Olson?
Mr.
What's
Olson.
Mr.
Tom
Olson's
Olson.
first name?
Tom.
Hearing nothing here. Mr. Eisenhoff, is there anything else you wish to tell me?
No, Your Honor, I was just showing up for the auction that they have, that you guys have on every Thursday. And I just showed up and bid against 4 other people. And This is my first time I've ever bought property through a foreclosure, so I did everything by the letter of the law and filed everything, bought it legally and properly, and so I'm just trying to follow through with what I did legally, Your Honor.
A lot of materials were sent to the court prior to today's hearing date. And first of all, again, I indicated on the record that this looks like a foreclosure that was initiated through Big Brother's bail bonds. And going over the case, the actual affidavit of publication shows that default occurred in the conditions of a mortgage made by Pamela Charles, you, Miss Charles, to Big Brother bail bonds. And they posted this as required. And I do have an affidavit of the publication. The publication indicates that the redemption period is for a period of 6 months. So you had 6 months to attempt to redeem this property. After the 6 months passed, this went to a sheriff's sale, and that means people can bid on the property. You could have as well, but apparently Mr. Eisenhoff was the successful bidder. And again, the property is no longer yours. It now belongs to Mr. Eisenhoff, as he was the successful bidder at that sheriff's sale. Since that time, Mr. Eisenhoff has provided some additional documentation, specifically some tax documents that he filed with the court prior today. And this indicates that through the records of the Allegheny County Treasurer's Office, that he, Troy Eisenhoff, is in fact now the property owner of 118th Avenue. And we also have, it looks like, a delinquent tax notice from Valley Township that he provided us, again indicating that the property is in his name. So the best I can tell you, Ms. Charles, is at this point, this is his property. He would like you off of his property, and I'm only allowed to give you under Michigan law 10 days unless Mr. Eisenhoff is willing to give you any additional time. Mr. Eisenhoff?
I'm good with 10 days, Your Honor.
Ms. Charles, I'm going to indicate after hearing, I do find that Mr. Eisenhoff is the owner of this property, having purchased it at a foreclosure sale rather, and that he does have a deed to the property at this time. You provided nothing as to any lease or anything, just that you were the prior owner, which you were. And again, it looks like you put this money up for collateral to a bail bondsman, and then they went and they foreclosed on that loan. So at this point, he is the owner of the property. He would like you to leave. I can't give you any additional time other than 10 days under Michigan law, and he's not allowing anything in addition. So at this point, you will have 10 days to vacate the property voluntarily, or after 10 days, Mr. Eisenhoff could request that the court issue an eviction order, and a court officer would actually perform the eviction. So hopefully, Ms. Charles, you'll be able to voluntarily leave within that 10-day period. If you have any additional questions regarding this between now and the 10 days, I would again strongly recommend that you contact Legal Aid of West Michigan. They may be able to give you some assistance free of charge. But again, at this point, a judgment is going to be entered, and you will have 10 days to voluntarily leave before Mr. Eisenhoff could obtain an eviction order. With that, you're both free to hang out from the court proceeding this afternoon. Mr. Eisenhoff, since you do not have an attorney, court staff is going to prepare that for you, and they will send that out to each of you in the mail. Good luck to each of you. Thank you.
Thank you.
Next matter this afternoon is our file number 2502793 LT. This is the case of Zachary Allen versus Johnny Trosper, Faith Berman, and any other occupants. Is Johnny Trosper present this afternoon? Is that a yes?
Yes.
Is Faith Berman present this afternoon?
Yes, sir.
Is Zachary Allen present this afternoon?
Yes, sir.
Okay. Mr. Allen, have you worked out anything with the people involved in this case, Mr. Trosper or Ms. Berman?
No, I have not.
Okay. To the two defendants, it looks like you were before the magistrate in this case back on the 19th of September. At that time, we're advised of your rights to counsel and financial assistance as required. We adjourned this. It was adjourned, it looks like a couple of weeks out here, more than just the 7 days, probably because of Mr. Allen's incarceration. Since that time, no legal aid attorney has filed any appearance on your behalf. Mr. Allen has filed what's called a termination of tenancy complaint. They indicate that he is the owner of Lincoln Road in Allegan, and that he would like the two of you to leave. He is not requesting any money. He's just requesting possession of the property to be returned back to him. So Mr. Trosper or Ms. Berman, do either of you have any type of a written lease that you believe allows you to legally stay on the property on Lincoln Road?
Yes, sir.
And could you provide that to the court?
Yes, I can copy this right after this and bring it to the courthouse.
Okay, what does it say?
It was a paper that
It's
he
a
got
piece of paper
notarized.
that,
One at a time can speak. Mr. Trosper, go ahead.
it's a paper that got notarized stating that I'm allowed to live on the premises. He got it notarized back in March. It's set for the commission expires 9/22/2030, and he did it on March 5th, 2025.
That's not how long you get to stay in the property for. That's when the notary's ability to stop notarizing ends.
This is Mr. Allen had this notarized.
How
Can
long?
I say
does it
something,
you
Your
can-
Honor?
No, I'm going to ask you a question in a moment, Mr. Allen. Mr. Trosper, how long does it say you have a right to stay there?
It doesn't state, mine and Zach's original agreement was I fix his house up and then I could stay here until I could get back onto my feet in my own house. And
The question was, what does the legal lease that you have in your hand say as far as how long you can stay there?
it doesn't specify,
It
sir.
doesn't. Okay. So as of today, you have no lease that says you can stay there.
I guess not, but it's saying
Okay.
that the paperwork, I'm here without permission, and paper says that Zach gave me permission to be here.
Okay. I'm not as concerned with that portion of it. That just would involve how soon you'd have to leave. But at this point, are you paying him any rent as of right now, Mr. Trosper?
No, sir.
Or are you, Ms. Berman?
House?
No? Okay, so you're both living there free.
I mean,
Okay. Mr.
like,
Mr.
utilities, but like not rent.
Okay, Mr. Allen, this is your chance to tell me anything. First of all, what is the nature of this property? Is this a home or what's located at Lincoln?
So I've been incarcerated. My father had passed away, and it's hard for me to do everything from in here. And I was trying to get it to where my girlfriend could live there with them. So I had wrote that document up, trying to like tell my mom, hey, my girlfriend can be there, because they wouldn't let my girlfriend live there with them. So that's what that document that they have stated. Since I've been home, I came home March 14th. No, I came home December 27th. But when the day I got locked up, they just moved in. So I got told I had to live with that by my probation officer and everybody. So I was gonna live with that. When I came home March 14th, and I lived with them, but nothing was getting paid. My mom was paying everything. Everything was in my mom's name. I seen it was stressing my mom out, so I moved out. I moved out to my mom's. Nothing's been getting paid since then, and I just want my house back. I want to be able to come home and live there. I come home in 4 months. I'd like to be able to come home and live in my father's house. I just legally went through the probate, paid the $175 to be PW, I think it is. So I finally just legally I wasn't even allowed to put them in the house. Legally, it wasn't even my house when they went in there. But now I just legally did that a couple months ago before I got incarcerated again. I'm just back on a probation violation.
Mr. Allen, are you willing to give them some additional time to voluntarily move?
No, I really just want the house back for real.
Is there anything else, Your Honor?
I'm sorry, go ahead.
Could I add some to my side?
Sure, go ahead.
When I moved in, I was under the impression that this was Zachary Allen's house. It wasn't on probate because it is currently in probate. It's not Zachary's name. It's still in his name. He served me the eviction notice
The 30-day notice.
before he had the property. And I didn't know that until I went down to the courthouse. Went down and filed for probate after he gave the eviction notice. That's not the steps you need to do it. You need to file the probate process and then get the person out of your house.
I've been PW before it even went into court.
They said it, he started the probate process on the 24th or the 25th, and he was incarcerated at that time. Somebody started that for him.
He was incarcerated September 2nd. These court paperwork filed 9/9. So he was incarcerated a week after he was incarcerated down and filed
For
paperwork.
him.
He didn't file any of this.
I don't know what they saying, Your Honor, because honestly, I went there myself. Went there, me and my girlfriend did, and my PO was aware of it. My PO told me to go there.
I called and they told me what day he got picked up on. It was September 2nd. This paperwork got filed on the 9th. It's a week difference, sir.
And Your Honor, we weren't just moving in here. Zach asked us to move here to help him get on his feet. And he's a registered sex offender. I had to go and sign papers for him to be around my son. Like, I wasn't just, we voluntarily moved in here. He asked us to for help. And Johnny was legally his sobriety coach.
Wait. He's a registered sex offender. You had to sign papers for him to be around your son as a registered sex offender. But you didn't choose to move in there. Like, you moving in there and not paying rent was all a favor to him because your boyfriend there is his sobriety coach? I'm not really buying that line of BS. You're living somewhere basically rent-free. All you're paying is utilities, and you think you're doing him a favor? My God, it's a pair of homosexuals.
I've done a lot of work in the house. That agreement was I fixed the house to make it livable because it wasn't livable.
Yeah, we had to pay the 2022 property taxes so that it didn't get foreclosed.
My mom owes over $800 for
Mr.
light
Allen?
bill.
Mr. Allen, please
Yes.
don't speak. Someone filed a notice to quit, which is the first part of an eviction case on July 26th. Who owned the property on July 26th?
His father still. He didn't start the probate process.
Sir, please don't speak. Please mute Mr. Trosper, okay? He's interrupting. Mr. Allen, who owned the property on July 26th?
Trying to think what the dates are. I'm not exactly sure of the dates, but I went to do the
Well,
PW.
I'm sure of the dates because you didn't go to probate court for a month. You went to court in probate on the 25th of August. And at that time, sir, please don't speak. I'm looking at the paperwork you filed in the court. You said at that time the property belonged to Stanley Lee Allen and that you requested to be his personal representative. So at the time, you or somebody on your behalf in July filed a notice to quit. That would have been part of the estate, and someone from the estate would have had to have done it. And it looks like you didn't have the authority to do it from the estate until a month later on the 25th of August. So at this point, what he is indicating is that original 30-day notice to quit was not valid. And the 30-day notice to quit essentially indicates that you've got 30 days to move, or after that time, a court case would be imposed. So what I could do, Mr. Trosper, is to adjourn this out for a period of 30 days to give you that 30 days. But I will tell you right now, if in 30 days nothing changes, he will have the right to have you evicted. So I'm going to indicate to the clerk's office, we're going to back this up 30 days because of the notice issue up front. You'll have the same opportunity as you would have had with that 30-day notice to quit. At this point, he is indicating that you are living there free. You're admitting you're living there free. He wants you out, and it doesn't sound like there's any written lease as of right now that allows you to stay. But you are right as far as the notice, because at that time, Mr. Allen was not the person who had the right to file that, only the estate of, it sounds like, his father. So clerk's office will adjourn this out for a second 30-day period, and we'll be back in court in 30 days, and I'll put notes in the file as to what happened today. But at this point, I'm unable to proceed because Mr. Trosper and Mr. Berman, or Ms. Berman rather, have a little additional time to stay because you, Mr. Allen, improperly filed a notice to quit before you had the legal authority to do so. Matter will be adjourned for a period of 30 days, but again, to Mr. Trosper and Ms. Berman, I'm just telling you up front, unless something changes and Mr. Allen signs a lease and allows you to stay there, it doesn't appear that you have any legal defenses to his case. And after that point, you only have 10 days to move, or a eviction order could be entered. So use the time wisely. Maybe you can work out something between now and then with Mr. Allen. But again, I'm required now to adjourn this, and court staff will assign a new date and time. It'll also be on actually, I think what I'm going to do is just to set this on for a pretrial conference to keep it away from another Friday. I'll ask that the pretrial conference be set at least 30 days out. So you're both all set today. Court staff will assign a date and time for a pretrial conference. You'll get notice in the mail when that'll be. Pretrial conference will be just like this over the video, okay?
Hey, can I ask you something, sir?
I can't give you any legal advice, sir.
I ain't able to ask nobody. I mean, I'm kind of in prison, so.
Yeah,
That's
well,
like
you
my only
filed a
chance I get.
lawsuit, you are representing yourself. You filed a lawsuit, you have to act as
No,
your own
it's
attorney.
it's about a money issue. I don't understand, like, and my mom wanted me to ask, I don't understand it, so I was
Sir,
gonna ask
I
you.
can't give you any legal advice. That's not fair to the Trosper, or Mr. Trosper, and Mr. Berman. If you have any legal questions, you'd have to talk to an attorney, because again, you're representing yourself in this case, because you filed the case. But you
How
get
do
another
I-
notification.
Do you guys give court-appointed ones?
You do not get a court-appointed attorney unless there's a chance you're going to go to jail. Legal Aid of West Michigan handles civil cases, but they will not probably allow one on a landlord, only on a tenant. You could check, that would be your only option. Call Legal
So
Aid of
there's
West
no way
Michigan
to,
and let them know that you are the landlord and see if they will give you some assistance. They are the ones who would help you on a case like this, okay?
I just don't have nobody to ask. I ain't gonna have nobody.
You're all
So-
set today, and be looking for your next court appearance dates in the mail. Thank you.
Yeah, just go to the law library and you're going to find 100 prison lawyers. Oh, guys, get ready. It's Jill Gillette's debut.
And good morning, everyone. This is the time set for Greenwood County docket. Rocky, you want to take up your case?
Yes, sir.
Okay. Your client's name?
Thomas Spexler, Your Honor.
Thank you. Okay. I have this down for arraignment at this point in time. And do you have proposed announcement that you're going to make on this, Mr. Weitzman?
Your Honor, we're ready for arraignment. We will acknowledge receipt of the complaint filed in this case on or about February 15th of this year. Waive formal reading of that complaint. Enter a plea of not guilty and request a jury trial setting. I will tell the court that this is a pretty convoluted case. as cases go, it involves the alleged theft of cattle. And so we're going to need to do a lot of discovery and a lot of legwork prior to trial. I'm honestly probably looking at a jury trial date no earlier than May, if that's okay with the court.
Okay, any objection to a June date? Ms. Gillette and Mr. Whiteman.
No, Your Honor.
Okay,
What I will say is pay decent amount of attention to the details here as far as the dates go and who says what.
thank you. Well, that gives me what I need to go forward. And we're still not on the record. I'll go on the record here in just a moment. The jury trial date would be June 11. That's a Tuesday. June 11 at 9 o'clock.
Judge,
Yeah. Yes, Chris.
I think it'll be June 4th.
Okay.
Your Honor, June 4th, I'm actually on a vacation in Mesquite, Nevada on that day. Sorry.
Okay. Well, then we're going to have to move to, and Chris, you are correct. I was looking totally at the wrong date. So that is our Greenwood and Elk County jury trial date is June the 4th. So we're looking for a trial date in this case of October
22nd.
October
For the
22nd.
jury trial.
Thank you, Chris. October 22nd for jury trial. And it would be Thursday, October 17 for pretrial conference plea docket. So we're looking at a little bit less than a year out. Is there any objection, Mr. Weichman, to waiver of speedy trial getting to that point?
No, Your Honor, I'm gonna need the time, actually. I think the better way to do it would, well, I think
excuse me, I'm open to suggestions.
well, I think, I think whatever date, I think some of the time should be counted to the state, sometimes should be counted to the defense. But, I'm not sure that the speedy trial rules were even in effect yet.
And they're not going to be until I think it's about April 1 of 2024. Do you want something set prior? Do you want something set, for instance, in April to see where you all are at?
Sure.
Okay.
That would work.
And Miss Gillette, is that agreeable or not?
April's fine for a status judge, but I don't believe any of the time should be counted towards the state because I could go in June. But
I'm not making any determination in regards to speedy trial time. It's the court's understanding that is suspended up until approximately April 1. The court will take up argument at that point in time in regards to speedy trial matters. And that's why I'm trying to discuss the case with y'all, with both sides present informally, just in regards to scheduling. And I'm not making any determinations. I'm not making any adjudications here today. And there is no speedy trial counted against either party until the Supreme Court orders that back into force and effect. But let me look and see what.
Judge, would April 4th at 9 a.m. on the criminal docket work?
April 4th at 9 a.m. Does that work by Zoom?
Yes, sir.
And Ms. Gillette, does that work for the state?
for a control, I think that's fine, Judge.
All right, that would be a control setting to advise the court of the status of the case in regards to discovery. The court would more intelligently be able to deal with any speedy trial issues at that point in time after reacting to whatever the decision of the Kansas Supreme Court would be as to that constitutional right. Now, April 4, 2024, 9 a.m., control setting. And like I said, my dates, months for jury trial in Greenwood and Elk County are February, June, and October. So with all that being said, Rhonda will go ahead and go on the record. And before going on the record, Rhonda, I just needed to get Mr. Spexar's first and middle name, please. Mr. Weichman.
First name is Thomas J. Spexarth.
Thank you. My apologies for mispronunciation of any names as we go forward.
Okay, now we all just heard the lawyer didn't ask specifically for the October hearing date. The judge went through his available dates, and that was the one that got landed on. Nothing the defense attorney requested.
No problem.
Rhonda now will go ahead and go on the record. Case is entitled State of Kansas versus Thomas J. Spexarth, case number 23 CR 41, Greenwood County, Kansas. State of Kansas appears by Greenwood County Attorney Jill Gillette. The defendant, Mr. Spexarth, appears in person and by his attorney, Rocky Weichman. This matter does regularly come before the court this date on the docket, criminal docket, and this is for arraignment. And announcements to the court, Mr. Weichman.
Yes, Your Honor. We'll acknowledge receipt of the complaint, waive formal reading, enter a plea of not guilty to the charge, and request a control status date of April 4th at 9 o'clock in your court. And that's by Zoom, correct?
Yes, it is.
Okay.
This matter is set for a control setting April 4, 2024 at 9 a.m. Subsequently, the court has had the opportunity to discuss several issues off the record. I believe that any matters that need to be resolved by argument and by adjudication by the court would take place thereafter. Subsequently, Mr. Spexarth, I do need to make inquiry. Mr. Weichman has waived your right, has waived your right to the reading of the charges herein at arraignment. The court has entered a not guilty plea, and the court has scheduled this matter for a control setting only, April 4, 2024 at 9 a.m. You do need to be present on that date, either at Mr. Weichman's office, as you are today, or at the Greenwood County Courthouse. Otherwise, I do retain you on the bond that you have previously posted. I do order you to stay in contact and communication with Mr. Weichman, along with your bail bondsman. Keep them both advised all times, your current address, telephone number, place of employment. Mr. Spexarth, do you have any questions?
No, Your Honor.
Anything further to come before the court, Ms. Gillette
Not from the state, Your Honor.
and Mr. Weichman?
No, sir.
There being nothing further to come before the court, court is in recess.
Thank you, Your
And
Honor.
you all are free to go.
Thank you.
Thank you.
Okay, then Judge, next could we do, sorry, I'm not sure how to pronounce his name, Rocky?
Thomas Spexarth, Your Honor.
Okay, thank you.
Sorry about that, sir. I didn't want to butcher your name.
Okay, before going on the record, any proposed announcements to the court? And Mr. Whiteman?
We're here for a status conference today on this case, Your Honor. According to the journal entry of arraignment, this case is already set for pretrial on October 17th at 9 o'clock. The jury trial is already scheduled for October 22nd through the 24th at 9 o'clock. And so we just are here for a status hearing on that.
Okay. We'll go on the record. Case is entitled State of Kansas versus Thomas Spexthardt. Case number is 23 CR 41. State of Kansas appears by Greenwood County Attorney Jill Gillette. The defendant, Mr. Spexthardt, appears in person and by his attorney, Rocky Weichman. This matter does regularly come before the court this date. This was set back today for status control setting, and the matter, I believe it's been set. Mr. Weichman advised for the October jury trial setting, which would be on Tuesday, October 22nd, and pretrial on the 18th.
I have the 17th of October at 9 a.m. for pretrial.
Yes, court stands corrected. The 17th for pretrial at 9 and jury trial on the 22nd at 9. Any resolutions of the case today, Ms. Gillette?
I don't believe there's one today. I may get in touch with Mr. Weichman again if he wants me to call him.
Okay. Court notes, matter still remains for pretrial conference, plea hearing on Thursday, October 17, 2024 at 9 a.m. and set for jury trial Tuesday, October 22nd, 2024 at 9 a.m. In the interim, Mr. Spexthardt, the court does order you to remain in contact and communication with Mr. Weichman, along with your bail bondsman. Keep them advised all times, current address, telephone number, place of employment. Any other matters to come before the court? Ms. Gillette?
Not on Mr. Spexthardt, Judge. Thank you.
No,
And
Your
Mr. Weichman? There being nothing further to come before the court, court is in recess.
Thank you.
Everyone, have a good day. And Mr. Weichman, do you want to take up your case?
Sure.
Okay. And your client's name?
Thomas Spexthardt, Your Honor.
Thank you.
He's behind me.
Thank you. All right. First case on the Zoom docket today is State of Kansas versus Thomas Spexthardt. Case number 23 CR 41. The State of Kansas appears by Greenwood County Attorney Jill Gillette. The defendant, Mr. Spexthardt, appears in person and by his attorney, Rocky Weichman. This matter does regularly come back before the court this day for pretrial conference, plea, docket purposes, and announcements to the court. Mr. Weichman.
Your Honor, I filed a motion to dismiss last week for a violation of my client's speedy trial rights, and I'm prepared to argue that if the court is wanting me to.
All right, state's position, Ms. Gillette.
Your Honor, speedy trial rights have not run.
All right, argument, Mr. Weichman.
Yes, sir. My client was originally charged in this case in 2023. The date that the court should be concerned with today was the date of our arraignment, which was November 16th of 2023. There was an arraignment that day. We requested a jury trial. The court set jury trial for October 22nd, 2024 at 9 a.m. At the time of that arraignment on November 16th, 2023, the speedy trial provisions of the the statute KSA 22-3402 were not in effect by two reasons. Number one, by administrative order of the Supreme Court during COVID, and further, the legislature had stepped in after the Supreme Court issued their administrative order and had amended KSA 22-3402 on April 20th of 2023. The important provision of that statute is KSA 22-3402, subsection M. Subsection M says no time between March 19th, 2020 and March 1st, 2024 shall be assessed against the state for any reason. More importantly, that paragraph says any person arraigned before March 1st, 2024 shall be deemed to have been arraigned on March 1st, 2024 for the application of the Speedy Trial Statute. Therefore, my client was arraigned on November 16th, 2023 prior to March 1st, 2024. However, the statute deems that he was arraigned on March 1st, 2024. He is not in custody. He was not in custody. He was out on bond. And 22-3402B states that any person charged with a crime and held to answer on an appearance bond shall be brought to trial within 180 days of arraignment. That arraignment date for purposes of speedy trial is March 1st, 2024. Therefore, the latest trial date that could be set by the court, absent some exception, would be August 28th of 2024. The court even set a control date in this case of April 4th, 2024, 1 month after the statute went into effect. At that control date, the state did not file any motion for a scheduling order, any motion to move up the trial. They did nothing. Therefore, the speedy trial ran against my client August 28th of 2024. No exceptions apply under the speedy trial statute. And so we're asking that the court dismiss based upon the fact that my client was not brought to trial within 180 days of March 1st, 2024, that the earliest trial setting set by the court was October 22nd, which is almost 2 months after the speedy trial statute ran. Therefore, we're asking the court to dismiss this case. Thank you.
Thank you, Mr. Weichman. Let me get the dates once again. March 1st, 2024 was the effective arraignment date that the defendant argues pursuant to Supreme Court order and legislative action. So March 1st of 2024. And the defense is arguing that the latest date for trial in this matter, 180 days, would have been August 28, August 28 of 2024, and we're up to October of 2025 at this point in time.
We're October 22nd, 2024 was the first trial setting by the court. All we're arguing is that his speedy trial rights were violated August 29th of 2024. What happens after that is of no consequence because the speedy trial rights were violated back then. And I apologize. I honestly was not familiar with the statute until a couple of weeks ago when I started looking into this speedy trial. I knew that when we got arraigned on November 16, 2023, that speedy trial was not in effect pursuant to Supreme Court order. And I thought basically that if he got arraigned while no speedy trial was in effect, that would apply throughout the case. But based on this legislative action in April of 2023, that's not the case. The case is that he was deemed to have been arraigned on March 1st. Therefore, the county attorney should have taken some action, and she had the ability to do so and was given that by the court when you set the control date to hear any motions or whatever on April 4th of 2024, and nothing happened. At that time, she should have filed a motion to move the case up or a motion for a scheduling order or something. Nothing was done. My client's speedy trial rights have been violated and the case needs to be dismissed.
Thank you, Mr. Weichman. And argument, Ms. Gillette.
Your Honor, speedy trial did kick in on March 1st of 2024, but here's the problem. At our hearing, when he was arraigned, November 16th of 2023, the dates of February 13th, 24 were offered to the defendant, but he was unavailable, and so was Mr. Weichman. They requested to have a new date pushed out at the defendant's request and the defense request, as they were not available for the 2/13/24 date. The court offered at that hearing, and I make extensive notes a lot in my file as to who requests what and when for this very specific reason of speedy trial. So when February did not work for Mr. Weichman, we offered June 4th of 24, which was the court's very next trial date. Mr. Weichman declined that date on behalf of his client and said he would be in Harvest June 4th of 24. Therefore, he asked for another continuance and a further date to be set for jury trial, at which time Mr. Weichman said, we can't do it until later in the year. And he asked for the October 17th, 24 date. Those continuances are all able to be charged to the defense because they requested a different date because they were not available.
One problem, though, I don't know if Jill realizes this, they weren't continuances. We heard it for ourselves. Those don't count as continuances. No, continuances are motions filed with the court. That was an off-the-record discussion of available calendar dates. So right here begins the start of Jill's absolute BS, lying and misrepresentation to the court.
So until October 17th of 2024, all the time should be charged to the defendant for not being available for trial. Once for Mr. Weichman being pre-scheduled and once for the defendant being in Harvest. Then we met for a pre-trial date status in April, and Mr. Weichman again requested we keep the date for October because they were not available in June and they weren't available until October. When we got to October 17th for the pre-trial, Mr. Weichman again said his client was now in bean harvest and asked for another continuance at the defendant's request. I believe at some point they said they would waive speedy trial because of all these continuances they requested. But I have notes that he would be in Harvest in October the next week and that it was a burden for him to miss Harvest. And Mr. Weichman, the defense, asked for the continuance. At Mr. Weichman's request, the jury trial was set to June 16th of 25. In the meantime, we filed an amended complaint. At that time that we filed the amended complaint, we changed the date and the amount. It wasn't a substantial change. The state did not ask for a new preliminary hearing. Under the law, there is this case called State v. Clements, CLEMENCE. State v. Clements. Its site is 36 Can App 2nd 791, decided in 2006. It is also 145 Pacific 3rd 931. In that case, the state moved for a new preliminary hearing, not the defendant. And the new preliminary hearing was set, and there were numerous continuances by the state for a witness, not a whole ton, but enough that the state had pushed it out a ways. When the state requests the preliminary hearing, the time is charged to the state. When the defense, as in this case, requests the preliminary hearing, the time is charged to the defense's motions. We were then set to go over back to Judge Webster for a preliminary hearing. It was set for July 8th of 25. Mr. Weichman and Mr. Spexarth waived preliminary hearing, and we were set for a new arraignment July 31st of 25. Mr. Weichman and his client then pled not guilty, asked to keep the current pretrial conference and trial setting. So absolutely zero time is attributable to the state because the defense made all of the requests of the trial dates to be pushed out. Not once has the state ever requested that, nor did we ask for the preliminary hearing, as in State v. Clements has made clear. Therefore, all of the time is charged to the defendant.
I'd like to
Thank you,
respond.
Ms. Gillette. Excuse me.
I'd like to respond to that, Your Honor.
Yes, Mr. Weichman.
That's not what I recall. This has been a long time ago, November 16th, 2023. As I recall, we requested a jury trial at that time. I think Ms. Gillette is getting some of these things mixed up because of the length of this case has gone on, but I recall requesting a jury trial, and I recall, Your Honor, looking at your calendar and immediately telling us the earliest you could set this case for would be October of 2024.
No, you were offered the February date, you were offered the June date, and you specifically said the defense was not available for June 4th, 2024 as well. And then you asked for an October setting, and when we got to October, you said your client was in harvest, and you even excused his absence.
What? Never did they ask for the October date. The October date was offered by the judge as the next available date after the June hearing that he already had plans for. And in all of the hearings, his client was present. He never waived his client's appearance for any of those hearings.
As I said before, to the best of my recollection, Your Honor, I'm just trying to recall what happened 2 years ago. 2 weeks ago, I contacted the court and the court clerk and asked to listen to the audio from the arraignment on November 16th of 2023. Nobody, despite numerous emails sent, despite numerous phone messages left, nobody has got back with me and said, yeah, you can come out and listen to it or we can send it to you. But I think we need to listen to that and see what happened. And if I'm wrong, I'm wrong. But I'm filing this motion based on my recollection today. And that's why I wanted to verify that. I don't want to misrepresent anything to the court, but this is what I recall. And I remember being shocked at the arraignment date because everybody, the court, the county attorney, speedy trial was not in effect. So the court, I think, as I recall, said the earliest date I could try this would be October. And I think that was the initial date. I could be wrong, but I think that the February date that she's talking about and the June date
those were all after this initial arraignment in November of 2023. But like I said, I think we should listen to the audio, but that's where I'm at.
If he's asking for the audio, technically the transcript is the official record of a court, and he would need to order a transcript, not just listen to it. I mean, the court can listen to them, but technically the transcript is the most appropriate thing. And if he's asking to order transcripts to have this motion heard on the full record, I made extensive notes. Maybe he needs better note keeping, but I make notes as to who requests what continuance specifically because of this purpose. I've had too many defense attorneys request continuance after continuance after continuance of the jury trial for numerous reasons. And then when we get there, they want it dismissed because they asked for too many continuances. And that is the problem in this case.
Thank you, Ms. Gillette. Thank you, Mr. Weichman. Court will take a 5-minute recess. I need to review the file. I'll be back with you. Court's in recess. Right, we are back on the Zoom record. The record may reflect presence of respective counsel and the defendant, Mr. Spexarth. Court, at this point in time, number one, I do not have a court reporter assigned to this division of the court. There are 3 court reporters in a pool that has been designated by the chief judge. It is court's understanding that in order to obtain a transcript of proceedings, it would be necessary to contact the court administrator, Dawn Roush, 316. That way, a court reporter may be assigned to produce a transcript of any previous proceedings herein. Subsequently, the court considers the Zoom record until the same has been reduced to a written transcript by a certified court reporter. The court considers the same, that being the Zoom proceeding that is on a system that can be reviewed. The court considers that the same as written notes that the court may keep, and subsequently the court does not consider that the same as an official record. So subsequently, the court and Mr. Weichman, the court does give defense the opportunity to review the same, present any of that specific information back to the court in regards to the motion that has been placed before the court, that the court is violating Mr. Spexarth's constitutional rights as to speedy trial. Subsequently, the court will schedule instruction conference for jury trial, and that would be on Friday. And let me ask Belen, do we have anything scheduled at 1:30 on this coming Friday? I know we have what shall cause docket at 2:30. Do we have anything at 1:30?
We do not.
Okay. So the court would have an hour to take up jury trial instructions. Court retains the jury trial for in force and effect beginning on Monday. That would be.
Judge, I have a hearing at 1:30 with Judge Webster on her regular docket. And I am also subpoenaed to be out of town in another trial to testify in an official capacity as an attorney.
Okay, the court will take it up over the noon hour. The court will take it up over the noon hour. And that would be on this coming Friday, Friday at noon. And well, let me say, I'll put it at 12:30. And we'll take up the matter at that point in time after Mr. Whiteman has the opportunity to review and present the Zoom record that the court considers the same as trial docket notes that may be taken. And then the court at that point in time will take up jury trial instructions. Please have your jury trial instructions to Belen, let's say by 11 o'clock on Friday. That would be tomorrow, 11 o'clock Friday. All right, anything further to come before the court? Mr. Weichman?
No, Your Honor.
And Ms. Gillette?
No, if he requests any audio, video, or transcripts, I'll be asking for a copy of them, and we would ask that all time be charged to the defense because this is their motion, and they have moved for this speedy trial motion. So I believe since this is also their motion, this time should be charged to them.
Well, we're not requesting a continuance of the trial date except for Monday.
That's the court's understanding. The court understands there is no motion before the court for continuance of the trial beginning on Monday. The court is giving Mr. Weichman and the state opportunity to more fully review the record herein. And the court would also appreciate a spreadsheet presented back to the court as far as what is the state, what the defense is delineating as time that is chargeable to the respective sides, the respective parties. All right, any other matters?
No, sir.
There being nothing further to come before the court is in recess.
Thank you.
Y'all have a good day.
Thank you.
And once again, good afternoon.
This was today's hearing. I forgot to change the date on my copy and paste.
This is time set for continuation of the defendant's motion to dismiss for violation of his speedy trial constitutional rights. Also set for tentatively set for a jury trial instruction conference. And let's see, Mr. Weichman, was your client intending upon being present or not today?
He is. He's just went to the restroom. Oh, he's back.
Okay, we'll let Mr. Spexarth get situated so he can follow the proceedings. And at the last hearing on, actually yesterday, the court had requested what I termed a spreadsheet, also a timeline in regards to the speedy trial issue. I have been able to take the opportunity to develop the same for what I need for purposes of ruling, and I will be more than happy to hear argument from respective counsel, beginning with the state and Ms. Gillette.
Your Honor, the defense on 11/26/23, as we talked about yesterday, announced immediately he would be ready no earlier than May. We would have had a February date and we would have had the June date available right away. And then Mr. Weichman, when we talked about the June date, immediately said he was on vacation in Nevada and he couldn't do it in June. He requested an October date. All of those are the defense requesting to push it out to October. When we were off the record, which is kind of one of the reasons I like to go on the record before we start having announcements, arguments, because some of this stuff gets missed then when we have the abbreviated versions. He still continued to want an October date. We could have gone at any of those prior dates. February, which is before the March 1st deadline, the June date, but he wasn't going to be available, all the way to October. Then we had a status hearing April 4th, and he still wanted the October jury trial date. He was not going to be available for June. So all the time from that time till October 22nd should have been charged to the defense. Now, Mr. Weichman in October of 2024, on October 14th, 2025, filed a written motion asking the court to continue the jury trial last October. He wanted it continued because his client was in the middle of harvest. His combine broke down and he was in a bind and had to go take care of his harvest issues. He would have needed to be available for the October date. And again, the defense was not available, but the state was. So then it was set over to February. The defense filed motions and wanted to push it out, then wanted a new preliminary hearing. And he filed that motion back in February, but never wanted to be heard on his motion. And then we didn't end up having the hearing until April 25th. And that is when further continuances and items were decided. Everything was pushed out again. And Mr. Weichman again asked for a continuance on April 25th, 25. Again, we were ready to go and have been ready to go, but he waited clear till the April hearing to ask again for an October trial date, as he was not ready for any other date. So it was pushed out at defense request again to October. And made by the defense. I don't believe any time is attributable to the state. I even said I didn't believe that any of the time was attributable to the state back when we started this in November of 23. And he has continued to want to keep the October date. Because he continues to not be available, not have his client available, and therefore the trial's all been moved at the written motion or oral motion of the defense. The state has yet to request a continuance. Anytime we gave them the discovery early as he did, letting know how much his discovery costs were. We got the discovery over to him and asked him to pay his discovery.
Ms. Gillette,
yes.
The court advises that we're losing you for some of your argument.
Oh, sorry, Your Honor. I'm subpoenaed to testify in the judicial center over here soon. So, I wrote a contract for some individuals that I have to testify on. But we have constantly been ready, got the discovery to him. As soon as anything was available to me, he received it within days, if not hours. There's nothing that's ever been held back as far as evidence is concerned. And it's been on the part of Mr. Weichman of not being prepared up until today.
Thank you, Ms. Gillette. And announcements or argument to the court, Mr. Weichman.
Thank you, Judge. First of all, I want to thank the court for giving us the opportunity to come back today. It was very helpful in that the court referred me to Dawn Roush. She was very helpful. She sent me audio, actually the video and the audio from both the hearing on November 16th, 2023, and also the control hearing on April 4th of 24. I sat down last night and listened to that word for word. On November 16th, 2023, we were set for arraignment before Your Honor. Initially, off the record, this is all off the record. Initially, I requested a date in May of 2024 or before. The court responded and said, does anybody have objection to a June date? Both counsel responded no. The court said the June date would be June 11th. The court was then corrected by an assistant and told the jury trial date would be June 4, 2024. All I said was, I'm on vacation that particular day. I did not say I was on vacation for the month of June, contrary to Ms. Gillette's statement. I simply said I was on vacation that day. I was available any other day in June for that hearing. Regardless, the court then asked me off the record if I had any objection to waiver of speedy trial to get it to October of 2024. Initially, I said no, I'm going to probably need the time actually. But as the court noted, I was immediately after I said that, I told the court the better way to do it would be assign some of the time to the state and some to the defense. I also said that I didn't believe the speedy trial was in effect. The court agreed with me and said, as it understood, speedy trial would not be in effect until April 1st of 2024. Actually, that was incorrect. According to the legislature, it went back into effect on March 1st of 2024. Upon seeing that no agreement could be reached, the court then said, do you want something set, for instance, in April to see where you are? Question mark. Ms. Gillette said that would work. I said, sure. Ms. Gillette then said, April is fine, but I don't think any time should be counted against the state because I could go in June. Off the record, Your Honor then said, I'm not making any determination as to speedy trial time. It's the court's understanding that that is suspended until April 1st of 2024. The court will take up argument at that point in time as to speedy trial matters. That's why I'm trying to discuss the case with you all, with both sides informally, just as to scheduling. I'm not making any determination, any adjudications here today. There is no speedy trial against either party until the Supreme Court orders that back into force and effect. The court then looked at its calendar and determined that April 4th, 2024 would be a good date for a control setting. The court asked both sides if that will work, and both sides said yes. The court went on to say that would be a control setting to advise the court of the state of the case in regards to discovery. And more importantly, the court went on to say, and that the court would be more intelligently be able to deal with any speedy trial issues at that point in time and to react to any decision of the Kansas Supreme Court would be as to that constitutional right. The court then went on to reiterate that my jury trial dates are February, June, and October. At that point, the court went on the record. The courts then announced the case was set for arraignment. I acknowledged receipt of the complaint, waived a formal reading, entered a not guilty plea from my client, and I requested a control status date of April 4th, 2024. I did not request a trial date. The court then stated that it had discussed matters off the record and stated that, quote, I believe that any matter that needs to be resolved by argument and by adjudication by the court will take place thereafter. The court then inquired of Mr. Spexart as to whether he agreed with my waiver of the reading and the entry of the not guilty plea. Mr. Spexart said that he agreed. The court then stated, this is very important. The court then stated, the court has scheduled this for a control setting only. On April 4th, 2024, the court did not set a trial date. However, as I put in my timeline, in parentheses, I noticed that when we received the journal entry of arraignment, the jury trial date of October 22nd was put in that jury trial or that journal entry of arraignment. We come back to the court on April 4th of 2024. The court asked both parties if there were any announcements to the court. I responded and said simply that we're here for a status conference today on this, and according to the journal entry of arraignment, this case is already set for pretrial and jury trial is set for October 22nd. That's all I said. All I did was announce what the journal entry of arraignment said. The court then went on the record. The court announced that this matter comes before the court for a status control setting. This matter has been set for 10/22/24 for jury trial and pretrial on 10/18. The court then corrected itself and said the pretrial is actually set for 10/17/24 and the jury trial is set for 10/22/24. The court then asked of Ms. Gillette if there were any resolutions. She said none today. The court then again noted the pretrial was set for 10/17/24 and the jury trial was set for 10/22/24. The hearing was then closed. The problem for the state is that the legislature, effective March 1st, deemed Mr. Spexar to be arraigned on March 1st, 2024. The court, albeit off the record, on November 16th, made it quite clear to Ms. Gillette that you were not taking up any determination as a speedy trial and that we would take that up at April 4th at the control hearing. She was on notice that she could do that, and honestly, she didn't. And more importantly, if she knew the law, March 1st, my client was deemed arraigned and speedy trial was already set. And it was absolutely abundantly clear from your order on 11/16/23 that you were not making any speedy trial determinations and that the only thing the court was doing on that day was setting a control hearing. Now, when the journal of arraignment gets filed, all I did was announce that this is what the journal of arraignment says, is that a jury trial has already been scheduled. Ms. Gillette had the opportunity to stand up at that point and say, wait a minute, Judge, we got a problem. We got a speedy trial problem because we did not acquiesce. We did not do anything. All we did after arraignment was ask for a control date of April 4th. That's all I did. I didn't request a jury trial, and there were no continuances requested by the defense from November 16th until October. By then, and I want to be clear, we are not talking about any time after October 22nd, 2024. For the purposes of argument and the statutory speedy trial, Mr. Spexarth and I will take every day of that. That's not the problem. The problem here is that Mr. Spexarth has a statutory and a constitutional right to a speedy trial. We are simply and exclusively relying on the statutory speedy trial right, meaning that he was arraigned on March 1st of 2024, deemed arraigned, and therefore should have been brought to trial by August 28th. Through no fault of the defense, none whatsoever, did we ever request a jury trial date in October. It was set by the court. And Ms. Gillette, I'm sorry, but she should have recognized the problem and said, like the court told her in November, hey, we're coming back here in April. We'll take up speedy trial at that time. Who knows? Maybe I was available then for June. I was never given that opportunity. And I'll refer the court to State v. Queen. State v. Queen has an excellent different holdings about what's supposed to happen. The defense is not required to do anything. The defense cannot acquiesce, but passive acquiescence doesn't count. According to State v. Queen, I didn't even do that. I simply read and followed what the court's order was. The court order of the journal entry arraignment said we're set for jury trial in October 22nd. And I don't have a duty to do anything else other than show up for that jury trial. So my client's speedy trial rights were violated on August 28th of 2024. This case should be dismissed for a statutory violation of his speedy trial rights. And honestly, Judge, I've talked about this with my client in depth last night, this afternoon, this morning. We want the court to get this correct. This morning, I requested transcripts, written transcripts from these hearings so that the court would feel comfortable in arguing. If we want the court to get it right, we have taken every day of time counted against us since October 22nd of 2024. We agree with that. We want the court to get it right. And if the court feels that it needs time to get this right prior to going to trial and wasting time of a 3 or 4, this trial is going to be 3 or 4 days next week. But we will take the hit.
If you watch the rise and fall of Jill's chest, she's fuming.
We want the court to look at the transcripts. We want the court to be advised in the proceedings. And that's what we're asking the court to do if the court feels that it can't rule on this right now. That's all I have, Your Honor.
I believe that Mr. Weichman has misspoke and misled the court again today, like he did yesterday. Because when he first came on and the court asked Mr. Weichman any announcements, he said, well, I'm not going to be ready until after May. And he is not saying that he said, I will not be ready till after May. And then when the jury trial date for June was brought up, Mr. Weichman himself said he was on vacation. He wanted the hearing date in October. The October hearing date for trial was selected when we were on the record all together. And then Mr. Weichman said that the October date would be fine. And the court asked about speedy trial. And at first he wanted to waive it. Then he was like, no, I can't waive it. I think it should be split. And it should not be split. That is Mr. Weichman asking the court to move it out to October. And I believe he has misspoke to the court again today, just like he did yesterday.
Be very careful, Ms. Gillette, about what you accuse me of, because I'm reading from exactly what I heard on the audio and on the video, and you're misrepresenting what was said by the court and when it was said.
Wait just a moment, Ms. Gillette. Ms. Gillette, it's the court's understanding that Mr. Weichman went to the time and he took the opportunity.
I did too.
What are you interrupting me about now? Miss Gillette, what are you interrupting me about now?
I watched every video last night too until 10:30, Your Honor. I downloaded all of them from Don Rouse, got them all from Don Rouse, not two, all the hearings, all 5 hearings I watched last night. And I sat through a lot of the previous hearings because a lot of them were the last ones on the docket. And so I watched all 5 hearings last night, and Mr. Weichman comes right out of the blocks and says, I won't even be available until won't even be ready until after May, when he first got on the very first hearing in November. And he's leaving that.
True. That's not true.
Miss Gillette, Mr. Weichman is an officer of this court.
And so am I.
And the court understands you are an officer of this court at this time.
Oh, at this time? Is that a little foreshadowing, Judge? Judge is pissed.
Subsequently, you are claiming that Mr. Weichman is falsifying the record that is before the court. Is that correct?
Judge, I think he is misquoting what was in those hearings. He said he would not be available until after May. He's trying to leave that out. And we all discussed the trial date of October because he wanted it in October. That was not me saying it was in October. We wrote down the trial date and we kept the trial date in place. We all wrote down that it was going to be in October when we were speaking off the record, picking a trial date.
Ms. Gillette, it's the court's understanding that Mr. Weichman, to the best of his ability, recited back to the court verbatim what occurred at those hearings. You're saying that is not correct. Is that
Not
correct?
correct. I do not believe he has recited verbatim because I watched them, all of them, last night. Every
As
single
nearly, you watched them, but you did not recite back to the court verbiage today. Mr. Whiteman recited verbiage back to the court.
If I may, Your Honor.
And is the state prepared to have transcripts produced of these hearings to come back before the court for subsequent review, subsequent argument? Ms. Gillette.
Absolutely, Your Honor. I watched the same videos he watched last night, and he came out of the blocks when we were off the record. But I want the off the record portion from the beginning all the way up to us going on the record, because he says out of the block, I won't even be ready until after May.
That's not true. I said I request a trial date of May or before.
No, you said I will not even be ready until after May.
Well, Your Honor, I can tell you this. I sat down last night and I listened to this word for word, and I stopped it and I wrote it down what was said, and then I played it 10 more seconds, and I wrote it down. 10 more seconds, wrote it down. There was a lot of stuff, yeah, that happened off the record. But what's important is what's on the record and what the court said. And the court said, I'm setting a control status only. I'm not making any determination as to speedy trial. Put Ms. Gillette on notice that she would be entitled to argue that on April 4th. The court did not set a trial date on the record. No trial date was set. No trial date was agreed to. And the court simply said, I'm only setting this for a status hearing on April 4th. You even told her at that time, you're going to be able to come back and we'll address speedy trial on April 4th. She neglected to do that. That's not my client's fault.
He specifically asked for those dates when we were off the record before we went onto the record. So I believe he's leaving all of that out. And it's very important that the stuff that was discussed off the record be included as part of the discussions, because Mr. Weissman came out of the block and said, I'm not ready until after May.
I wish the court would compare my timeline. I will stand by my timeline. I am an officer of this court. I've got 35 years experience. I've never been accused of misleading a court ever until today. And I will stand by exactly what's in my timeline. And I urge the court to get the transcript to show that Ms. Gillette is the one that's misrepresenting anything, if at all. It's not me.
The court orders transcript of proceedings. The court orders this be at the cost of the state. And subsequently, the court will reschedule this matter for further argument. I can advise that it's going to take a court reporter some time to prepare the transcript. The court advises counsel that I have, and I'm going to check with my administrative assistant, Belan, to see what time we have available on my Greenwood County docket days for November 13, December 18, and if we have any days available, Greenwood County for January. So court at this time is off the record for purposes of scheduling.
And we're not going to trial on Monday either, right?
That, well, I'll go back on the record, but that is correct.
Thank you, Your Honor. I appreciate that. I really do.
Your Honor, how much time are you needing?
I don't need, I just am gonna have council limited to 15 minutes of argument. And
Okay.
then I will go ahead and enter a ruling at that point in time. It shouldn't take more than 30 or 45 minutes.
Okay. Um, we have several scheduled on the afternoon docket on the 13th of November, but we would have time later in the day. And then December the 18th, we have time also. Do you want the
Okay.
January date?
No, I think that December 18 gives our court reporters enough time.
So the charge is apparently theft of cattle, which is why all of the transitions have been grazing cows.
To get that prepared. And I think that Mr. Whiteman is familiar with checking with Don Roush, the court administrator, in order to get this assigned out to a court reporter to get it into a written form and in a transcript. And subsequently, the court would ask that Mr. Weichman, you have Don assign this to one of the 3 court reporters that we have in the district, and that court reporter then would make demand upon Ms. Gillette for the cost of that transcript, and that needs to be provided and paid for in a timely manner back to the court reporter.
Oh,
And
I have no problem asking for the transcript,
I
Judge. I'm the one.
Miss Gillette, I cannot understand you. You're breaking up.
I have no problems, Your Honor, asking Dawn for the transcripts. And I want the part that's off the record as well from the very beginning, because I'm the one that emailed Dawn yesterday for all the hearings and gave specific dates of every hearing so that we would have all 5. And Dawn responded to my email that included everyone, including yourself and Mr. Weichman, with the videos.
We don't, the court is not finding anything that would be beneficial as far as determining violation or not of Mr. Spexarth's right to speedy trial that would occur past the October 17. So I only need what is set forth on a Zoom type of record after arraignment of November 16, 2023. These are the dates that I have. November 16, 2023, April 4, 2024, and October 17 of 2024. Those are the 3 dates that the court would pinpoint. I'm open to correction, Ms. Gillette or Mr. Weichman, if there's other relevant dates for the court to take into consideration. Ms. Gillette?
Judge, if I feel one of the others is important, and I'm going to go back and watch them all again, I'll go ahead and order them just to be safe.
You were breaking up again. What was the first part of your statement?
Judge, I will watch all of the videos again. I've already watched them last night, but I will watch them all again. If there's anything else relevant, I will have it transcribed. I will order it.
That is not the question that I asked you. The question I ask is, what are the relevant dates to request transcript for?
There is an email for us that is from Dawn. We have November 16th, 23. We have 4/4/24, 10/17/24, 4/25/25, and 7/31/25. Those are all of the hearings where we were before, Your Honor. There was,
I don't, excuse me for interrupting. The court doesn't need anything past October 17.
Okay.
That's the time period the court's concerned with. And in particular, the time period between March 1 of 2024 and I've got down March 1 of 2024 when the Kansas Supreme Court resumed the statutory speedy trial. So between March 1 of 2024 and April 4 of 2024, I calculated 34 days. And between April 4 of 2024 and October 17 of 2024, I calculated 196 days. And that would be a total of 230 days. So that's what the parameters are. We need to be judicious in regards to court resources, and those are the dates that the court would request that Mr. Weichman advise that the court is in need of the entire transcript of proceedings by Zoom during those points in time.
Your Honor,
Yes, Belen?
may I interrupt?
Yes.
The court reporter and administration is asking me, Mr. Weichman has already ordered 2 transcripts. Is the state responsible for the payment of that?
Well,
Or is
the
Mr.
court,
Weichman?
I'm ordering the state to be responsible for the cost of the transcripts herein.
Of all the transcripts?
Yes, all of
Okay.
these transcripts, yes. The
And
only
then-
exception, Belen, if Mr. Weichman wishes to have his own copy, then he needs to pay the copy rate. He needs to pay for a copy.
I will do.
Okay. And then also, do you want the off-record portions in that in those transcripts as well?
Say again, Belen.
Do you want the off-the-record portions of the transcript in the transcript as well?
Off the record,
Do you want the full transcript?
I don't think the off the record discussions that occur are necessary. I think the court is careful about going on the Zoom record and coming off. Is there any objection to that, Miss Gillette?
Yes, I want the off the record discussion because that's where Mr. Weichman says he is not available till May.
Doesn't matter to me, but I think for purposes of this motion, the only relevant dialogue is once we're on the record. But if the court wants to listen to off the record, I'm totally fine with that. Totally fine with that.
Okay, well, the state is paying the cost of off the record and on the record discussion. So the court understands that Miss Gillette is making a demand for the entirety of off the record discussion and on the record discussion. Is that correct, Ms. Gillette?
Absolutely.
Is that a yes?
Yes, absolutely.
And that is a yes.
I think the judge is making it pretty clear, even if the words are in the off the record discussion, they are not going to be considered because they're not on the record.
I said yes, yes.
Yes. Pardon me?
We need all of it.
All right. I think we've got do we have a time set on that December day?
Not yet, Your Honor.
Okay.
I'm open all day.
Okay. Belen, what type of time do we have available? Greenwood County for December 18?
At 1 o'clock, we have a domestic case. So we may want to move it out to later in the day. We have 2 or 3 available.
Okay. How about we put this at 3 o'clock on Thursday, December 18?
You said 3 o'clock?
Yes, 3 o'clock.
Okay,
Argument to come before the court December 18, 2025 at 3 p.m. Court finds both counsel available for argument. And once again, I think the instructions are clear. Mr. Weichman is to once again order the transcript as requested by the state off and on the record for the 3 dates and subsequently that the court has previously enumerated, and the state is to advance the cost of that transcript with if Mr. Weichman wishes to have a copy, he'd need to pay for his copy.
Yes, sir.
All right, anything further to come before the court? Ms. Gillette
Not from the state.
and Mr. Weichman.
No, Your Honor.
There being nothing further to come before the court is in recess.
Thank you.
Everyone have.
Oh, just wait, just wait. I couldn't resist. I made that when I went off camera. Oh, I love you guys. There we go. You guys are absolutely hilarious with your puns. Oh my God, I was laughing so hard. You know, puns are my absolute favorite with dad jokes right there with them. Oh, golly. Oh, my stomach hurts so bad. And I wore my black and white spotted top today. Oh. So, yeah, that was so much fun. I absolutely love you guys. The coffee's still in the kitchen because I had to come back because because I knew the judge was gonna blow on her and I just had to be here for it. You know, I watched it while I was editing it, but that wasn't enough. I had to see it again. But now we're gonna go see Judge Wiggins.
Mr. Waterman, are you able to see and hear me?
Yeah, I can hear you and see you.
All right. Mr. Wetterman, did you have the opportunity to meet with somebody from the defender's office today?
I have not.
All right. I have a complaint that alleges that on or about September 22nd, 2025, in the city of Cadillac of Wexford County, it is alleged that you committed the offense of malicious destruction of fire or police property, in particular a phone kiosk. That is a felony punishable by up to 4 years in prison and or a fine of $5,000. Do you understand that is what you've been charged with and that's what the potential penalty is?
Yeah, I completely understand.
All right. On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and you have the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, Mr. Wetterman, are you asking to hire an attorney, have one appointed, or represent yourself? I believe you have an appointed counsel on another case already. Am I correct on that?
I do. I believe he was wearing the chartreuse kind of Joker looking costume, the same one that like Mr. Champion was wearing today for some reason. Okay. I don't know his name, but yes, he is appointed to me.
All right, the court will go ahead and we will make an appointment for an attorney in this case. We'll enter a not guilty plea and we'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove two things. One, probable cause that the crime had occurred, and two, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. If they are able to do that, the case would be bound over to stand trial in circuit court. Prior to the preliminary examination, there will be a probable cause conference. That's where your attorney and prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, am I correct? He's sitting in there right now for throwing windows through the sheriff or rocks through the sheriff's department window?
That's
the allegation.
Yes.
Yeah.
Yeah.
All right. And
Is there pending competency determination in that case?
yes, so I ordered
Okay.
ordered competency back on August 25th. Obviously, a bed has not opened up. The court is going to sua sponte on its own order competency in this case as well. Mr. Harrison, any comment regarding bond?
I believe that discussion would be somewhat academic at this juncture until we get his actual status sorted out with regard to the forensic center, what stage of the process he's in, et cetera, et cetera. And in a sense, I guess that bond determination would have to be made before this one. I would have you set a bond, so whatever credit could be allotted later, we can figure it out from today's date to whenever.
All right, thank you. Ms. Lawrence?
I agree with Mr. Harrison, Your Honor. I would just ask for a monetary bond.
What was his bond in the other file? Do you remember? Look that up. Bond in the other file was set at $75,000. I'll set bond in this file at $25,000 cash surety with the following conditions: that Mr. Wetterman, you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. Additionally, you are not to act in any threatening, violent, or intimidating behavior. Thank you, Mr. Wetterman. Next arraignment, jail.
So you guys have a nice day.
Thank you. All right, court calls the people of the city of Cadillac versus Colin Shane McInerney. This is case number 252469 OD. Appearances, counsel.
Meg Carnes on behalf of the people.
Thank you, Your Honor. Taylor Ann Cavano on behalf of the defendant who joins us from the front of jail being Zoom.
Sir, are you able to see and hear the court?
Yeah.
All right, are you okay?
Yeah, I just have a little bit of anxiety.
Okay, all right.
Thanks for your
We are
concern.
here, we're here on a sentencing to a plea that was taken yesterday to an operating while visibly impaired. We adjourned till today for the court to be able to review the substance use assessment. Mr. Carnes, I see you have it in your hand. Do you need some more time to look at it?
No, I reviewed it, thank you.
Do the parties have any corrections or additions to the assessment?
No, Your Honor, I reviewed it with my client.
Okay.
No, Your Honor.
Mr. McInerney, before we get into sentencing, I have a question for you. I read in the assessment, and what it says is that he disclosed remembering the police approaching him as he was on the ground and being taken to jail, where he stated, "I remember I was babbling and talking nonsense." Yesterday, you gave me some facts to find you guilty. My question to you today is, do you actually remember the event of driving?
Yeah, I got images in my head, like what happened. I faintly remember, yeah. I drove up onto the yard and I played music in his yard and I just miscalculated the turn. I hit his house.
And is that your memory, or did that come from a police report or somebody telling you what happened?
That's my memory.
That's your memory. Okay. All right. The only reason I asked is because I want to make sure that the plea we took yesterday was what you had remembered, and not what somebody had told you had done, because there would be a different process we have to go through. So I just want to make sure we didn't need to do a no contest plea in this case. So.
Okay.
Ms. Fioravento, any allocution?
Thank you, Your Honor. I would just also emphasize this assessment actually occurred back in June 25th. I have gone over those issues with my client, and his memory has improved over time. It's kind of come back to him over time. I did verify he wasn't mimicking anything from a police report. Otherwise, we would have discussed a no contest plea at that point.
Okay.
Thank you. No, as to allocution, Your Honor, my client is extremely remorseful, and I know he would also like to address the court today about how these events have helped him realize the negative impact of THC on his daily life. All of that considered, Your Honor, while he has had issues on bond, he has appeared for his court hearings. He is willing to abide by the court. He recognizes that he needs assistance. We would recognize too by our calculus, he now has 28 days. If we count yesterday, 29 days of credit. We would ask the court to take that into consideration as well. He would respectfully request another opportunity at probation to help get services and treatment and also community support resources. He is a person who has had on and off mental and physical health issues throughout his life. He has lost one of his strongest support people recently, as we discussed yesterday. He recognizes the need for those supports, and he hopes that if given those supports, he will be able to take full advantage of them and use them to not just remedy this situation, but going forward, remedy the things that have led him before this court now and in the past, so it does not happen again. Thank you.
Ms. Fioravento, did you say 29 days credit?
We have 27 in our system from his previously being housed. He couldn't initially, he sat for a period because he could not initially afford his bond. Our system shows 29 days. And then if he went in yesterday, 28, our system shows 27 days. He went in yesterday, if we count that as 28, and if we count today as 29. But I would leave that to the court how I'd like to count.
We calculated 25. So do you have
25?
Do you have his dates handy?
One moment, let me look in the file. So our system automatically calculates it, and then that is showing me 27 from the date of arraignment to the date that we received notice he had been released, but I have to look manually back to verify other components, to see if we have an arraignment sheet.
So it looks like he was arraigned on June 9th.
That's what I have.
I assume he went in on the 6th of June.
All I have is arraignment date of June 9th, Your Honor. Arraignment on June
He
9th.
was arrested on 6th.
He was arrested the 6th. When did he bond out?
It would have been just He may be able to give you a better idea of that, Your Honor. I'm looking at the file to see if we have that. It was just after he received his money from the state.
Sir, do you remember what day you bonded out of jail?
Yes, it was the 1st of July.
July 1st?
Yes,
And then you went back in yesterday, right?
that is correct.
All right.
If we got out on Tuesday the 1st, I have 27, Your Honor.
I come up with 25.
We went on Friday.
There'd be 24 days left in June. I mean, that he sat 24 days, the 6th to the 1st would be 24. Because he doesn't get credit for the day he bonded out.
All right, you are correct, Your Honor. I think our system is counting the day he bonded out.
It would still only be 26 then.
Today it's 26.
Well, he would get credit for yesterday, which would make it 20. Yes, correct. Yeah. Okay. All right. So we agree it's the 25 days.
Yes, Your Honor. Thank
All
you.
right. Mr. Carnes?
Thank you, Your Honor. This is a disturbing incident. Thankfully, nobody was hurt. But I can imagine, I mean, it's June 6th. People could easily be in the front yard and really have a truck rolling into a house.
I wasn't gonna hit that house, but then I got high.
It does sound like the defendant is remorseful and that this scared him. And I respect that. I sincerely hope that it's true and this behavior doesn't continue. However, with his behavior on bond, I just don't think he's supervisable. I'd ask the court to impose 60 days jail with no probation.
Refresh my memory, Mr. Carnes. When was this, in the evening or night, early in the morning?
It was dark. The body camera was dark. If you give me a second, Your Honor, I would give it.
All right, I want the guy who's down here now.
It was about 10:45 p.m.
And this was in the city, so it was a residential neighborhood.
Yes, it was a resident. There were two houses very close to each other. Occupants from both houses were out and concerned.
They were outside?
By the time police arrived.
Okay.
I don't think
All
anyone
right.
was outside when the vehicle hit the car. As the police showed up, there were multiple people outside. It was East Chapin Street.
East Chapin, okay. Did he go through an intersection and strike a house, or did he veer off and strike a house? Do you
I
know?
think he veered off the road. That's my impression.
I don't believe it was, he was like striking a house in the sense he went into the house, reviewing the police report. He was more like in the yard and kind of near a tree. It's not super clear.
It was reported he bumped a house. There was absolutely no damage to the house. So clearly
So he
wasn't
didn't
going
drive
that fast.
He didn't drive into the house.
He
hit the house, but he
right into
didn't.
it, but it looks like there was contact. That's what was reported by the people in the house.
It's from my understanding, the vehicle was found in the yard. Police were contacted, and then my client was found not far from the vehicle. He had gotten out and was found not far from the vehicle.
Do we know how far the house was from the street? Was that in the report anywhere?
That's not in the report. The report says the Silverado truck was stuck at the top of an embankment, the residents stopping the vehicle. I think it was close to the street. That's my memory from watching the body cam.
Does it matter? Clearly, the house was not in the road.
If the court will allow, I can pull Google Maps of the property.
Sure. Mr. McInerney, while your counsel's bringing up a photo of the house, is there anything you'd like me to know?
Yeah, I'd just like to say that I've come to the realization that although marijuana may not be a heavy narcotic, but when you spend all of your time, money, and effort into getting it and consuming it, it does become destructive. And I feel like one of the reasons why I'm in oranges right now is because of THC, and I really feel like I'm never gonna smoke marijuana again. I just had enough of it. It's caused too much chaos in my life.
When did you come to that realization?
Just over the last couple nights. Like it's useful. Like I'm on a low income, so I don't really can't afford it. And then I just spend way too much time and effort looking for it. And it's not a heavy narcotic, but when you spend all your time, money, and effort looking for it, it does become destructive. And I don't want to smoke marijuana anymore personally myself. I've had enough of it. I only smoked it to fit in before in the past anyways, to find friends, and it showed me that it doesn't really attract good friends either. So I've had enough of marijuana. I don't want to smoke marijuana anymore personally.
Your assessment says that you use it for maybe some medical purposes, even though you might not have a medical card, but you're using it for some anxiety issues.
Yeah, and a little bit of depression, but the positives that it has does not outweigh the negatives that it's caused in my life. Like it's taken my time, my money, and my effort, and now it's taken my freedom, I feel like. And I can't deal with this no more. It's not worth it.
And did I also read in the assessment that they had been playing around with your medications a little bit?
Yes, we tried a new medication that I had an adverse reaction to, and I couldn't eat nothing for 3 days because I felt like my gallbladder was going to explode every time I put something in my mouth.
Well, the assessment indicates that you don't have a substance use disorder, which is a good thing. Now, Ms. Fioravento had indicated that you would like to be placed on probation for some services. So what services would you like to see out of probation?
Maybe some sort of anger management service that I could get through them, because I have an anger problem because I'm bipolar. And now that I'm 40 years old, I'm able to communicate a little bit better and control my anger better. But just like things like, because my truck broke down too, and I might need some guidance into getting like the Salvation Army and how to figure out how getting help to fix my truck, my dad's truck. And I think having a little bit of support from people outside of my circle would be a really positive thing for me. So I think probation would help me transition to a different part of my life where I'm not smoking marijuana anymore.
I assume you've been on probation before, given some of your prior history. Am I correct on that?
Yes, I have been on probation before.
Were you successful with probation?
I believe I was successful, but then I was also unsuccessful one time. But that was back when I still had the addictive mentality, and where I felt like I'll never quit smoking weed. That's how I felt in the past. Now I'm like, get it away from me, man. I don't want to be around it.
Well, I hope that's true. It's concerning that, you tested yesterday and tested positive for THC. When was the last time you had used it?
I'm not gonna lie, it was yesterday in the morning because of my subconscious mind just going through the steps in the morning. I woke up and I hit the pipe and like, oh shit, I shouldn't be doing this. I gotta go to court today. I have a clear head.
Oh my goodness. You just got done telling the judge that you came to this realization over the past couple of days that you didn't ever want to smoke again. But then right before court, you smoked. Good move. Let's see how the judge likes that.
How much do you use a day?
Well, in the past, I'd consume as much as humanly possible, but like I said, I don't want to be around this stuff anymore. Like if there was another joint to smoke, fire it up, I'd feel. But
okay, anything else you'd like me to know?
Not really. I think it's time for a change in my life, and I think if I remove THC from my life, like drug I'm addicted to, then it would produce a lot more positive outcomes in my life and bring me to a lot better place in my life if I stop smoking marijuana.
Okay. Mr. Carnes, was there any restitution requested in this case?
No, there was not.
Ms. Ferventa, were you able to find a
Yeah, I was
photo?
able to pull up a Google map, just kind of a street view if the court wants to see that.
Yeah, if you could approach me.
Prosecutor.
I've reviewed it.
Sorry, I've got a privacy screen on, so it's a little hard to see. Let me know if you need to change
What-
your angle.
Do we know which house it
It's
was?
the blue house. It's the blue house,
The
right?
one right in the middle, huh?
That's my understanding.
Okay. All right, thank you.
Your Honor,
Yes.
I'd just like to add one more thing that, like, when I do get out of here, the first thing I'm gonna do is go empty my bag of weed into the toilet and smash my pipe. Like, that's what my intentions are, no matter what the outcome is. If I sit in jail or whether I'm on probation, that is my goal, to smash that pipe and dispose of that weed.
I've got one more question for you. You had said yesterday, the reason why you weren't testing when you were supposed to is because you couldn't get to Cadillac. How did you get to Cadillac yesterday for court?
My mother came and picked me up. Well, she came and picked me up the night before, and I stayed the night at her house. So she had to come pick me up in the morning. So
Are you mom? Ma'am, are you his mother? All right. And she's in the courtroom today, just so you know.
Okay.
Well, sir, this could have gone in an entirely different way for you. You're very lucky that you didn't crash actually into that house. When I saw the street view video, that was quite a hill that you would had to have climbed to even get up to that house. And had you been going fast enough, it may have even launched you into the house. So you're very fortunate in that regard. And you're also very fortunate, at least the photograph I saw, there was a big tree in front of that house that you didn't strike that tree and wind up seriously injured or worse yet, dead. Because you have requested probation and you've indicated that you were successful with probation in the past, you may have stumbled in another incident, but you have completed successfully. And I think you have outlined some areas in which you're asking for assistance. And I think hopefully we can point you in the right directions and give you some programming for that. Like I said, the assessment shows that you don't have a substance use issue, shows you have no disorder, but you're telling me you're addicted and you smoke it basically all day long if you could. So that raises some concerns. I understand that there might be some issues with some change in medications, but as I recall, the labs that Mr. Carnes cited yesterday during the plea, you had some very high levels of THC in your system. So I think it is appropriate to place you on a period of probation for a couple of reasons. One is to help you with any addictions that you have, and two is to try to keep the community safe. I don't think, while you earn the right to sit in jail, I don't think jail is going to help you. I think you need to be out working services as opposed to sitting in the jail. So your jail sentence is going to be 25 days jail with 25 days credit. All right, so you'll be released at some point today. I'm going to put you on a period of probation for 24 months. During that time, you're not to violate any law. You are to report as ordered, and you cannot leave the state of Michigan without the consent of your probation officer. And you must also keep your employment and your contact information current. Now, this charge does allow you to be released early. So if you've done everything we need you to do at the 12-month mark, you can be released at that point. If something happens where your probation officer doesn't think you should be released, but you think you should, you can file a petition on your own and we'll have a hearing and I'll make that decision as to whether or not you should be terminated from probation successfully. Do you understand that?
Yes, sir. Yes, Your Honor.
Also, I'm going to order that you attend the alcohol highway safety education class and the victim impact panel. I'm also ordering no illegal drugs, including recreational marijuana. I realize alcohol was not an issue in this case, but I'm also going to order no alcohol because I don't want you trading one substance for another substance. Right. And you'll be subject to testing pursuant to the terms of your probation officer. I also want you to follow the substance use assessment recommendations, which are basically to stay clean. Okay. I'm ordering any counseling that your probation officer feels is appropriate, including for drugs and alcohol.
Well, if you really wanted to stop using marijuana, I guess This is your chance.
and any other programming that she feels is necessary. Now, you mentioned anger management. I'm going to mark that if she determines that it's appropriate. All right?
Okay.
Because it wasn't really a driving force behind what happened here. It's not like you got mad and crashed into a house. So
Right.
it's not really appropriate for me to put you into classes for that. But because you're asking for it, I'll let her make that decision. All right?
Okay.
There is a $75 Crime Victims' Rights Fund fee, a $50 state minimum fee. You're on SSI, is that correct?
Supplemental security income, yes.
All right. How much a month do you get?
$948 a month.
Are you your own payee?
Yes, I am my own guardian.
All right. Given your income, I'm going to waive the fine. I'm going to waive the court costs. I'm also going to waive the attorney fee. I am going to charge you 12 months of probation, which is $360. If you end up staying longer than the halfway mark, you're going to have to pay the monthly probation fee. Mr. Carnes, any reimbursements requested?
Your Honor, it's a blood draw, $200 to the Cadillac City Police Department and $100 prosecution.
Sir, the law in some instances allows for recoupment of some of the costs in prosecuting these types of cases. And OWIs happen to be one of those. So I'm ordering $100 reimbursed back to the prosecutor's office and $200 reimbursed back to the City of Cadillac Police Department.
Can I just pay all the fines to the courthouse here?
Yes.
Okay.
Yep. Even though I have sentenced you to time served, you do have the right to appeal that decision. And if you decided that you wanted to appeal it and could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. Also, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that. Do you understand that?
Yes.
All right. At some point, you'll be released today. If there's still time, I'll need you to contact you'll need to come over here to the courthouse and get signed up for probation at the district court
Okay.
probation office on the ground floor. You'll
Okay.
also need to stop here and make a payment. And if you're not able to make a payment, get signed up for payment arrangements.
Okay.
All right.
And where do I sign
Do you have,
up for payment arrangements? Where do I sign up for that in the probation office?
you can come to our front window at the court.
Okay.
Yep. So where you normally check in for court, they can help you there
Yeah.
for a payment plan. And then, like I said, the district court probation office is on the ground floor of the courthouse.
Okay. Yep.
All right. Do you have any questions for me at all?
No question.
All right. Good luck, sir.
Thank you, Your Honor.
All right. We are adjourned. Thank you.
Next matter this afternoon is our file number 2503053 LT. This is a case of Hunter's Glen versus Heather and Lewis Coleman Jr. and all occupants. Is Heather Coleman present this afternoon?
Yes, we're here, Your Honor. His name is Louis, not Lewis.
And is Lewis Coleman present this afternoon?
He just went into the bathroom.
Okay, well,
But
we can
yes,
get
he's
this
good.
started. I will trust you. He's going to be coming back. Any resolution of this case prior to today, Ms. Reed?
No, Your Honor, but some payments have been made, and I just wanted to bring to the court's attention. I don't know why, and I don't know if this is brought up with the magistrate. The rental rate on the complaint says, I think 2871, which is obviously incorrect. I have no idea where that number came from, but I just wanted to advise the court that's the incorrect amount.
I also have a question, Your Honor.
Okay, well, let me go back a little bit. Ms. Reed, it says 2871 per month because Matthew Pallets on 9/23 filed a complaint that said it was.
I doubled the numbers. I can't figure out where that typo came from, but the actual rental rate should be 1829.
1829, okay.
Yeah.
And just as long as I have you here with that reduced rate and some payments, what are you showing the rent to retain would be through the end of October?
Your Honor, the total that is due, exclusive of the court costs is 3836.05.
Okay, Ms. Coleman, you said you had a question. First of all, I just want to go back over again what happened here. You were before the magistrate, and it sounds like these numbers were way off, but in any event, we adjourned this for 1 week. They are now amending their complaint. They're indicating that the rental rate they put in of $28.71 was filed in error, that your real rental rate is $1,829 per month. Does that sound accurate, Ms. Coleman?
The rental rate sounds accurate, yes, Your Honor, but in this complaint, it says that our rent is paid through July 31st of 2025. We didn't move into this property until August 21st. So all of
Okay,
this
that is-
paperwork is inaccurate, and we have been more than willing to pay the rent, but the office would have to drop all of the court costs for incorrect filing.
Okay, I don't believe that's going to happen, Ms. Coleman, because again, the filing costs are the same, whether they have a correct date or a correct amount. That is their cost of having to bring you to court to collect your back rent. So how much do you think you owe on back rent if you wanted to stay through October? They're saying $3,836.05. Does that sound accurate?
No, Your Honor, they're saying that our rent is paid through July 31st. We did not live here in July, so the numbers that they've given us are inaccurate, and they've also added bills onto our account from the previous tenant who lived here for water and sewer, so the numbers on our account are not correct. Once those numbers are corrected, we will be more than happy to pay our rent.
And considering their admission to already making a significant bookkeeping error on the amount of their rent that they're seeking, that they've, been charging, I kind of am siding with the tenant on this one.
Yeah, very well. With that, we'll set this for a pretrial conference and then for a bench trial. So with that, Ms. Coleman, you're going to get a notification to come to court for what's called a pretrial conference. You'll be talking again to the attorney from your landlord, bring up any issues you have. If there's no resolution, the matter will be set for a bench trial. And again, based on what Ms. Coleman's indicating, I do find that there are issues of fact to be determined at trial that cannot be handled through a summary proceeding. So you are free to hang out from the court proceeding this afternoon, Ms. Coleman. You'll be receiving a date and time for a pretrial conference from the clerk's office in the mail. Okay?
Thank you.
Thank you.
Thank you very much.
Ms. Reed.
Have a good weekend.
You too.
Oh my gosh, I think that was probably the most fun stream we've had in such a long time. But I think that after every one of them, and yes, it has been 3 years. As of my birthday, October 12th, it was 3 years. I started streaming on my birthday, and it was supposed to be a one-off. I was going to do one live stream because at the time, I was just, making videos with, words typed in them and stuff. I was never going to live stream because, internet is cruel. You did not. You did not just do that. You did do that. Gas me out of my room. But yeah, so anyways, I live streamed on my birthday, and it was supposed to be once, and then I did it twice that day, and I loved it. I loved it so dang much. And I just haven't stopped. Oh. My nebs. I haven't been doing my nebulizers. I've been slacking. I did my inhaler before I streamed tonight. They're so time consuming, and then I have to take the stupid thing apart and wash it all. And no, I'm naughty. A farewell party for who? For Jill? Or did I miss a comment? Okay, I gotta clean the machine from last time. But that means I gotta leave you all. Oh, I'm wheezing some? Not really. I'm clear as a bell, as far as I can tell. I mean, I can hear when I wheeze. Central. It's 2:23 a.m. right now. Well, yeah, you gotta. I gotta pull the whole dang thing off the thing, and then I gotta take it all apart and wash this doodad, this doohickey, and the mouthpiece. And then I gotta wait for it to dry because I can't use it while it's got water in it. Well, they didn't issue me one of those. It is. Yes. According to my respiratory therapist, you do. If you are using tap water, and that's what I have is tap water. If you don't have filtered water, you are supposed to let it dry because your tap water has a lot of nasty stuff in it. You guys, I'm fine. Oh, that you know of. I gotta wash my oh no, I get to change my BiPAP mask tonight. I don't gotta wash it tonight. I just get to change it. Yay. All right, guys. It's 2:26. I apparently need to go wash my machine parts and then go to bed after I do a neb treatment. I'm not going to be able to sleep after I do this. Do you seriously know after you do these, like your heart's like, brrr, like I'll do it in the morning. I'll do it first thing in the morning. That's when my breathing's the worst anyways, because, well, the BiPAP, the animals, and yeah. allergies. My allergy med kicks off by that time. Yeah. Yeah, there was that night. There was that week. My neighbor still won't talk to me after that. He won't. Cause he saw me that night. I was draped over my railing, and he saw me. He went out and he was talking to the neighbor's dog while I was fighting to stay alive. And he got in his car and drove off. He didn't know. He thought I was just being dramatic or something. So, and he hasn't talked to me. I told him because I was upset. I was really upset. And he just walked away. But I can't really blame him. So, anyways. No, and this was after that. Because it was after that. Well, like, it was like a week later. He saw me and he goes, "You're mad at me, right?" I said, "I don't think mad's the word." He goes, you don't talk to me anymore. You're mad, right?" And I said, "You left me to die." He goes, "What are you talking about?" And I told him. And he just shook his head and walked away. The one thing he did say, he said, "I think I have this effect on all women." How many women do you know that you've left for dead? Has this happened before? Yeah. Oh well. I lived. I made it. And you guys all care about me. So, I've got that going for me. I love you guys so much. All right. I'm going to sign off now. And I'm going to go to sleep. And then I will wake up in the morning. I promise. Hey, man. I've got my SB7 spirit box right here. I actually did. I put it between our two houses because he's my neighbor. And I put it between my two houses, our two houses on the handicap ramp with the speaker with it, recording it. And then I learned that my recorder is too old to work with my computer. So I plugged it in and I got nothing. It doesn't even recognize a new device is plugged in. So the OS on that model is just a bit outdated. This thing's kind of old, but I've got stuff from when my recorder actually worked. But and I've got stuff from that night. I just can't, because you gotta slow it down. And I can't do that. I can't slow it down without being able to access the file. I can't access the file because my recorder is so old. I need to get a new digital recorder. I really need that in order for this to work. Can't do anything without it because I gotta cut the speed in half and crank up the volume. Yeah. Ooh. None of mine point that direction. The closest one would be the one at the bottom of my handicap ramp at that door, which I don't use that door because there's steps inside. So I don't use that door at all. It just stays dead bolted. But I have the camera there because it's got the doorbell, and in case somebody, thinks, oh, look, a door. I don't have to go down the ramp to tell them, hey, buddy. Anyways, yeah, that one, it points at their house, but not like I could see like if someone was coming and going like after they exited, but I can't see anything like right at their doorways. Yeah, and I wouldn't want to spy on them. I really wouldn't. It's not something I want to waste my time on. Yeah. So, okay. Quit engaging me in conversations. It's all your guys' fault. I'm going to be here till 4 a.m. if I keep this up. I love you guys. Be safe, be well, sleep sweet, and much love.